I'm attorney Todd Leneve. Welcome to West Virginia Gun Law. Today I want to talk to you about the right of illegal aliens to possess firearms. Stick around. On March 8th this year, U.S. District Judge Sharon Coleman, presiding in the Northern District of Illinois, issued a ruling in a criminal case against a Mr. Heriberto Carbajal Flores, an illegal alien here in the United States, with charges, among other things, of possessing a firearm as a prohibited person. My initial reaction on hearing about this ruling was that it was absolutely ludicrous. And so I, of course, immediately started looking into it. I found the opinion, had a chance to read it, had a chance to read a lot of the opinions that are circulating on social media, read some other U.S. Supreme Court cases that address some of the concepts that the judge discussed in her ruling, and watched some videos of some other attorneys on social media that I trust, and had a chance to really sit and digest this case and figure out from my own studies where I fall on this. And so let me be clear, I still believe that the judge got it wrong in this case. But I understand where she came from. I can see what her reasoning was. I just believe that it was flawed. So this case arose when Mr. Carbajal Flores, again, was found to be in possession of a pistol. And there was no evidence he had used it unlawfully, that he had committed any kind of crime with it. He simply had it. But the fact is that the federal law that prohibits him from having that firearm says clearly that it shall be unlawful for an alien who is in this country unlawfully to possess a firearm or ammunition. He doesn't have to have a conviction. The law doesn't require that a conviction be present as a predicate to charging him under this particular section. So in reaching her decision, the judge essentially said, he doesn't have any felony convictions, he doesn't have a history of violent crimes, and while he was on supervision by U.S. probation prior to his trial, he was fully compliant with all the rules that had been placed on him by probation services. In looking at his behavior and his history, the judge compared him to British loyalists at the time of the Revolution and the founding of the United States, and drew some comparisons between the manner that they were treated and the manner in which she believed Mr. Carbajal Flores should be treated. Now, it's important to point out that we've got a number of Supreme Court cases that say, in looking at the Second Amendment and in evaluating its applicability to a certain person, we have to look at the history and tradition of the Constitution relating back to the time of the founding of the country. And so at that time, British loyalists who remained in the United States were treated in one of two ways. Either they could sign a loyalty oath to the new country and they were then permitted to possess firearms, or if they refused to sign a loyalty oath to the United States, they were denied the right to have firearms. Now, these people were not being treated as though they were in the country unlawfully. These are people who, in large part, were already here, who were part of the colonies, and who remained during and after the Revolution. And so they had that option to make a choice. Am I going to be loyal to the new nation, or am I going to remain loyal to the crown? And there was a different treatment for them depending on what category they fell into. So Judge Coleman here applied that standard to Mr. Carbajal Flores, saying that British loyalists had been treated on an individualized basis, case by case, and that therefore he should be treated the same way. The difference, though, in my opinion, is that Mr. Carbajal Flores had an opportunity to come into this country legally. He chose not to do so, And by choosing not to do so, he essentially, like some of the British loyalists, chose not to become a part of this society, this country, chose not to become a citizen here. And so, just like the British loyalists who remained loyal to the crown and not the new nation, Mr. Carbajal Flores has separated himself from those class of people who chose to be here lawfully and those of us who are born here and are citizens of this country. So there is definitely a distinction, but I believe Judge Coleman got it wrong, in my opinion, by applying the rationale that she did and reaching the conclusion that she did. Now, the U.S. Supreme Court has previously addressed the issue of who's covered under the Second Amendment, and the truly groundbreaking case on that issue was the case of D.C. versus Heller, the District of Columbia versus Heller, which was a 2008 case. Among a number of other things that were addressed by the court, the concept of who we the people is was given a deep dive to determine who that really covers. Ultimately, without going into all the rationale and the history behind it, the U.S. Supreme Court determined that we the people refers to Americans. Imagine that. So, in continuing its analysis of the Second Amendment in that case, the court concluded that Americans are the people who are protected under the Second Amendment, whose natural rights exist and are protected by the Second Amendment from any governmental intrusion. So, in order to be clear, we do look at the fact that in this country we afford various constitutional protections to non-citizens. Largely that comes in terms of how we treat them within our judicial system. We give the protections of the First Amendment, the Fourth, Fifth, Sixth, and Eighth Amendment to non-citizens just as we do to citizens. But by and large, the Constitution applies to Americans, not non-citizens. Now, these amendments that we've just talked about largely, again, relate to the judicial process and what personally I believe is the desire by the founders of this country that we treat people humanely and fairly and with dignity. And while we certainly extend certain protections that I don't think we should to people who are in this country unlawfully, I do believe that in order to remain a civilized nation and to sort of remain that beacon of light within the world, we do need to treat people fairly and humanely within our judicial process. And so those amendments do in fact relate directly to the ability of a foreigner, whether they're here legally or not, to be protected under our laws. But to extend other protections that clearly apply to we the people just seems to be way off base. We have clear guidance, again, from D.C. versus Heller that says we the people are Americans. Clearly, Mr. Carbajal Flores is not an American, and therefore the Second Amendment should not have been applied to him. Now, the government most certainly will appeal this decision, and I think there's a very good likelihood that the 11th Circuit Court of Appeals, which is not historically pro-gun, is probably going to overturn the decision. But for now, the judge's ruling stands, and Mr. Carbajal Flores is no longer subject to prosecution for being an illegal alien in possession of a firearm. Listen, this has been a longer video, and I appreciate you sticking around and watching it. To me, it's a very interesting topic, and I hope it is to you as well. And I look forward to seeing what you all have to say. If you haven't subscribed to the channel already, please do so, and share the channel with others so that they can join it as well. Like this video, share it. Again, I know that a lot of people have heard about it, but there are an awful lot who haven't, and I think it's a great thing to get out for discussion among the people that you know that are in your circle. Thanks for spending some time with me again here today. I look forward to seeing the next video. Until then, take care.